So, very good morning, friends. Today, we'll start with this topic, management and administration. Although we had discussed up to question number 6, but let us again go back to this uh, case study on this management and administration. And I hope my screen is visible to you. So, I'll request Priya Venugopalji to please read the case study for the benefit of all.
Yes, sir.
Hmm.
Yes, sir. Reference section 96 to 122. Satyam Shivam Sundaram Telecommunication Limited is a newly formed public company engaged in the business of providing telecommunication services with its head office in Mumbai, Maharashtra. The company has an authorized capital of 100 crore divided into 10 lakh shares of 1000 each, which is fully subscribed and paid. The directors of the company appointed you as the company secretary to discuss about the managerial and administration setup of the company. The issue as to when and how the AGM and other meetings of the company should be held is under consideration by the directors of the company. The date of incorporation of the company, as recorded in the registrar office, is 18th June 22. The company has not held any AGM in the year of its incorporation, that is, till the date of closing of the first financial year of the company on 31st March 23. You are required to discuss on the issues of holding the AGM / other meetings by the company.
So now you have read the facts. Now please
Yes,
tell
sir.
me, in the second line, they have written public company. So whether this word public company will have any implications, whether there are different provisions for private companies and public companies in management and administration, please answer in yes or no.
Yes, sir.
Yes, there are different provisions because management and administration covers quorum, etc. also. And quorum is different
Mhm.
for public company and
Public company.
private companies. Now,
Correct, sir.
and there are other issues also. So we have to see whether it is a public company or private company while answering the question. That is also an important aspect. Because sometimes the examiner may ask you a question which is based on, say, public company, but they include in the options the option which are applicable for private companies also, just to confuse you. So you have to take
Yes, sir.
special care what type of company is it. Number two, whether this authorized capital, whether it has
Mm.
got any implication in management and administration. Suppose authorized capital of one company is 1 crore, authorized capital of
Mm.
another company is say 100 crore. So will it make any impact while answering our questions or not? If you do not know the answer,
Yes.
please note it down so that when we go through the questions, you will come to know which section talks of authorized capital. Now, another issue is whether this date of incorporation has got any impact on
Yes, sir.
questions which might be asked. Yes, date of incorporation has got an effect actually. Why? Because based on the year of incorporation, the answer may be different. So AGM may or may not be held in the year of incorporation. Just a minute. Let me check. Okay. So now, first things first. The first AGM of the company. Now let us start answering the questions. The first AGM of the company should be held within dash from the date dash of the company. What is
9
C,
months,
sir.
sir.
9 months from the date of closing of first financial year of the company. C.
Yes, sir. A.
Option C.
C,
option?
C, sir.
Yes, C is most.
Option C.
Yes, sir.
Yes.
Okay. So please note down your answers also because we will be displaying you the answer sheet at the end. So the first, any other option apart from C? Okay. Now second question. The AGM other than the first AGM of the company should be held within dash from the date dash of the company.
6 months.
6 months.
सी होगा, ये भी सी नहीं
C,
कहा,
C.
6 month सी
No,
होगा।
no, it's not
D.
C.
D.
D. D, D.
D is the option. Okay.
Hmm.
Now, third
Yes, sir.
question. The difference between the one AGM and the next AGM of the company should not be more than
15 months.
15
months.
months.
C, sir.
so
C.
C option. Okay. So please keep on noting down the options also which you think is correct option. So we will show you the answer at the end. Now, next question. The registrar may, for any special reason, extend the time within which any AGM other than the first AGM shall be held by a period not exceeding. Because the registrar has got the special powers.
3 months. 3 months. See.
3 months.
Okay.
See.
Any section which you can quote for this?
96.
96. Okay. Any subsection?
96 related to timing.
Or proviso, sir.
Has
The
it?
Proviso, sir.
Proviso.
Proviso, sir. Subsection
96.
1,
96 subsection 1 proviso.
proviso 3, sir.
Yes. So
One.
Third proviso.
it is actually third proviso.
Yes, sir.
Third proviso, provided also that the registrar may, for any special reason, extend the time within which any annual general meeting other than the first annual general meeting shall be held by a period not exceeding 3 months. So whether this power can be exercised for the first annual general meeting also? It is saying
Yes, sir.
other than the first
Oh,
AGM.
other than, no, sir.
No, my question is whether this registrar has got this special power for extension of time period in the case of first AGM also or
No.
other than first AGM
No,
only?
sir.
No.
No, sir.
No.
Okay. And first AGM should be held on
9 months.
9 months from the date of closing of the first financial
Closing of
Closing
the
of
financial year.
and in any other case within a period of 6 months from the date of the closure of the financial year. Okay. So answer is C here. Now, the AGM of the company may be held at where it should be held.
D. Both A
Any
and
place,
any place.
it's the company.
Any plus C, sir.
C, sir. C, sir.
D.
A and B. D.
Actually, you have to go to section 96.
A. D is a right answer.
96
C, sir.
subsection 2. What 96
Yes, sir.
subsection 2 says? And so should I open the other
Yes, sir.
Yes, sir. Yes, sir.
वो कहाँ गया? अभी करता हूँ। ये जो है ये वेबसाइट भी खोल देता हूँ अपनी ये वेबसाइट आ गई ठीक है जी और वेबसाइट में ये आपको
एनी प्लेस तो अनलिस्टेड कंपनी के लिए होगा ना सर।
Sir, it's option D, both A and B.
D.
डी तो इसलिए एनी प्लेस।
अब आप ये देखिए 96(2). प्लीज रीड 96 subsection 2. I hope my screen is visible now.
नो सर इसमें नहीं आ रहा है वो।
नहीं
No, 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 sir.
ये तो क्वेश्चन आ रहा है इसमें।
अभी आ जाएगा अब आ गया
Yes, C.
आ गया।
Yes, sir.
now it is visible. So 96
Yes, sir.
96(2) you have to read. Every annual general meeting shall be called during business hours, that is between 9 a.m. and 6 p.m. on any day that is not a national holiday, and shall be held either at the registered office of the company or at some other place within the city, town or village in which the registered office of the company is situated. Okay.
Yes, sir.
Provided that annual general meeting of an unlisted company may be held at any place in India if consent is given in writing or by electronic mode by all the members in advance. Now,
Yeah, this is correct. Mhm.
now again to the question. This was the question. So now what is your answer?
A and B, sir.
Sir, option D, both A and B.
Option D.
Both.
Okay.
Ah,
Option D. Yes. So next question. the AGM of the unlisted company may be held at, just now you saw.
Option D.
D, sir. Option D.
D, sir. D.
Option D or E?
Option D, sir.
D, sir.
ई होना चाहिए
Unlisted
सर, ई
company.
होगा, ई होगा।
No, no.
सर
Unlisted company.
प्रोविजो जो आपने पढ़ा उसमें वो तो ये भी
हाँ.
तो लिखा नहीं है सर।
Sir, proviso, it includes any
Provided
place in
96
India.
True,
आपने
sir.
बोला इन एडवांस जो बोला वही सर।
नहीं, मुझे तो
ये-
क्या लगता है, I think option should be E, because now another question, let me put it in other way, whether AGM of unlisted company can be held at its registered office? You will answer
Yes.
yes or no.
Yes.
Yes.
Can you hold it at some other place within the city, town or village in which the registered office is located? Yes or no?
Yes.
Yes.
Any place which the company thinks fit?
Yes.
फिट वाला
Yes.
किस में, किस प्रोविजन में आएगा सर?
No, no,
थिंक फिट वाला नहीं आ रहा है ना,
no, no. C doesn't apply.
थिंक फिट वाला नहीं आ रहा है।
सर consented and advance दो sentence वो लिखा था, that sentence it was written in consent and in advance, so I think that is the most appropriate.
Provided that annual general meeting of an unlisted company may be held. Now let me take you to the provisions again. What it says. This proviso says that annual general meeting of an unlisted company may be held. So it is an option only. Had they written yes, shall be held. So that means it is mandatory to hold it here. But it says may be held. So they are giving just another option. So this option is in addition to the options which are already given in section 96(2).
Correct, sir.
I think.
Yes, sir. Yes, sir.
So what
Yes,
we have to do, we have to reframe the options. So here the options will be A, B, and D.
D. Yes, sir.
All of the above except, you can say except
D.
C.
Mhm.
ठीक है?
हाँ ये ठीक हो
Yes,
जाएगा।
sir.
है ना?
हाँ सर।
Yes, sir.
So
लगता
now
है हम लोग का भी कंपनी एक्ट आ जाएगा सर,
है?
हम लोग का भी कंपनी एक्ट समझ में आ जाएगा धीरे धीरे।
अरे मुझे भी आ जाएगा, मुझे खुद ही नहीं आता। तो ई आंसर हो जाना चाहिए, है ना?
Correct, sir. Correct, sir.
हाँ, because we have
सर
to
एक
go
बात
as
है,
per-
कंपनी का रूल कहाँ पे है सर? आपने कभी कोई रूल का जिक्र करते हो सर? रूल?
अरे भाई, रूल में ऐसा है कि रूल में जब प्रेस्क्राइब लिखा होता है ना, तो वो उसमें उसको क्लिक करो तो वो आ जाएगा, रूल भी आ जाएगा। यहाँ पर कोई रूल है नहीं, इसलिए नहीं आया।
नहीं, अलग से रूल होगा ना सर, अलग से रूल तो होगा ना, ये कह रहे
रूल
हैं
तो है ही
अलग से है।
नहीं। इसमें क्या हुआ है, जैसे
लिंक
on
दे
our
दिया है,
website,
आपने अच्छा किया है, लिंक दे दिया है सर।
on our website what they have done is they have provided the link in the
हाँ,
section itself.
आसानी हो जाती है उसमें।
Yes. Bhai, please speak in English, otherwise Raj Shekharan ji will say what you are talking, I am not able to understand. Section 7. If any default is made in holding the AGM of a company under section 96, the tribunal may, on the application of any member of the company, call or direct the calling of an AGM of the company, and for this purpose, one member present in person or by proxy shall be deemed to constitute a meeting. Now it says, if there is a default and any member complains, so the tribunal can direct that, okay, you call the meeting and one person present in person or proxy shall be deemed to constitute a meeting.
Yes.
So whether it is true or false?
True, sir.
True.
True, sir.
Okay. So answer is C.
C.
And what is the section for this? Because you have to tell the section also.
97.
97. Yes. And if any default is made. So 97(1). 97(1) read with proviso. And a general meeting held in pursuance of subsection 1 shall, subject to any directions of the tribunal, be deemed to be an annual general meeting of the company under this act. So this is 97, section 97. Hint, we can say section 97. Next. So answer was C. Now, next question. The tribunal is entrusted with all the powers of calling, holding, or conducting a meeting of the company other than an AGM on the application of any director or member of the company or so moto, and for this purpose, one member present in person or by proxy shall be deemed to constitute a meeting. Now, what is the difference? This I think we have already covered.
No, 7 only we have.
Okay, 7. Now 8. What it says? Powers of the tribunal.
It's tribunal and 7 is true, sir.
No, what I'm trying to find out, what is the difference between 7 and 8?
Sir, that got, sir, in it is tribunal, sir.
So 7 was relating to the
7 is-
AGM and 8 is related to the other than AGM.
Yes. So now it is talking of other than AGM. And the section is
Section
98.
98.
98. So let me take you to section 98 also here. So 98. This is 98. What 98 says? I think now my screen is visible. 98.
Yes, sir.
Sir,
Yes.
sir,
if for-
make some bigger size, sir,
हाँ जी
थोड़ा सा बड़ा कर दो.
नहीं तो आप कहाँ पर देख रहे हो इसको? मोबाइल पर देख रहे हो? कहाँ देख रहे हो?
नहीं, लैपटॉप में देख रहा हूँ, लेकिन छोटा, मेरा आँख थोड़ा सा वीक है, सर.
हैं?
My eyesight is poor. My eyesight is poor. That's why I'm not able to see properly.
ओके ओके ओके. तो आपको तो प्रोजेक्टर पर दिखाएंगे फिर हम लोग.
नहीं सर, एक that's one kind of disease now that has taken my one eye and another eye surviving.
ओके ओके.
That's all the problem.
अरे भाई मुझे खुद ही नहीं पता कैसे इसको बड़ा करना है. एक मिनट.
नहीं ठीक है सर, ठीक है. I'll just manage it with it.
नहीं एक मिनट में देखता हूँ.
कंट्रोल दबा के सर और स्क्रॉल कर दीजिए, ऊपर हो जाएगा.
कंट्रोल दबा के
और कर्सर ये बढ़ा दीजिए, घुमानी ऊपर से कीजिए ना, हो जाएगा वो.
ऊपर से तो नहीं हो रहा.
हाँ
अरे पता है मोर में जाना होता है.
नहीं, इससे हो जाएगा ना. कंट्रोल
Sir, sir, this is enough, sir. This is enough. I am now able to read, sir.
नहीं किसका नहीं होता कैसे? कंट्रोल करके
कंट्रोल करके कर्सर को जो गोल वाला है ना, ऊपर नीचे कीजिए ना, हो जाएगा. वो ट्राई कीजिए, हो जाएगा.
नहीं वो तो मैं कर ही रहा हूँ. इससे तो नहीं हो रहा.
नहीं, कंट्रोल करके स्क्रीन को छोटा बड़ा उसमें राउंड है ना घुमाने वाला
भाई ये मैक्सिमम स्क्रीन है लैपटॉप के हिसाब से.
नहीं सर, इससे ज्यादा नहीं, और इससे आउट ऑफ स्क्रीन हो जाएगा सर.
हाँ.
इससे बड़ा होगा तो.
So 98, what it says, if for any reason it is impracticable to call a meeting of a company other than an AGM in any manner in which meetings of the company may be called, or to hold or conduct the meeting of the company in the manner prescribed, or the tribunal may either so moto or on the application of any director or member of the company who would be entitled to vote at the meeting, order a meeting of the company to be called, held and conducted in such manner as the tribunal thinks it. Provided that such directions may include a direction that one member of the company present in person or by proxy shall be deemed to constitute a meeting, and any meeting held shall be deemed to be a meeting of the company duly called. So even one person can constitute a meeting. This was the case. So now I read it again. So what is the answer? Section 98. What is the answer?
C, sir.
C, sir.
C.
True.
Okay. So
True.
number 8, C. And when we read it along with the provisions now, so most likely we will not forget. Now, this says if any default is made. So now this is regarding default, and it is given in section 99. So hint is section 99. You can even open Companies Act with you. Section 99. एक मिनट. Punishment. So this is the section related to punishment. If any default is made in holding or complying, company and every officer of the company who is in default with fine which may extend to 1 lakh rupees, and in the case of a continuing default with a further fine which may extend to 5,000 rupees for every day during which such default continues. So minimum fine is 1 lakh. And in
1
case
lakh.
of a continuing default with a further fine which may extend to 5,000 rupees for every day during
Every
which
day.
such default continues. Suppose there was a default of say 3 days, then what will be the fine?
1,15,000.
Yes. So now, what is your answer? You have already read this section?
Yes, sir.
Yes.
Option A.
Option A. Okay. Now, next question. The board may, whenever it deems fit, call an extraordinary general meeting of the company. First of all, you have to tell me the section. Which section governs this thing?
100.
100, sir.
100.
100, sir.
Okay. So hint is section 100.
100.
True, sir. A.
Acha. What it says, let us go to the section also.
Hmm.
Calling of extraordinary general meeting. The board may, whenever it deems fit, call an extraordinary general meeting of the company, provided that an extraordinary general meeting of the company, other than of the wholly owned subsidiary of a company incorporated outside India, shall be held at a place within India. What it says? So suppose there is a wholly owned subsidiary of a company which is incorporated outside India. So in that case, it can be held even outside India. But if it is a company other than of the wholly owned subsidiary of a company incorporated outside India, then it has to be held at within India. Okay?
Yeah.
So they can reframe the questions. This is just
Yes,
one
sir.
question. You can frame even 5-6 questions out of this particular section. So please don't think that, okay, if we have gone through this case study, then we are perfect in Companies Act. Nothing like that. You have to read each and every word in the section, and the board shall, at the requisition made by, in the case of a company having share capital. So there are different provisions, whether you are having share capital or you are not having share capital. So first is regarding in the case of a company having share capital. Such a number of members who hold on the date of the receipt of the requisition not less than 1/10 of such of the paid up share capital of the company as on that date carries the right of voting. In the case of a company not having a share capital, such a number of members who have on the date of not less than 1/10 of the total voting power. So in case share capital, not less than 1/10 of the paid up share capital. And in case of a company not having a share capital, then not less than 1/10 of the total voting power. Whether preference shareholders have got voting rights or not.
Yes,
No.
sir. If data has been involved by them, sir.
Yes, in case any resolution directly affects their interest, so they have got voting power. And what is the other thing? They have got voting or to vote on all the resolutions also. What is that provision?
Sir, if they are not received the dividend for 2
Yes.
Consecutive
Right.
2 years. Consecutive 2 years.
Yes, consecutive 2 years. So
consecutive.
we have to keep memorizing again and again. We have to keep repeating in our mind all
3
this.
years का है ना सर, वो 3 years का है ना?
2
No,
years.
no, no,
2
2
years.
years.
Sir, 2 years.
2 years.
Sir, that is for debenture holders, no, sir?
Ah.
Those who are not are getting the dividends for the last 2 years.
No, preference shareholders.
Okay.
Debenture holders will never get dividend. They get
Okay, sir. Okay, sir.
So मुझे खुद भी याद हो रहा है इसी बहाने. Call an extraordinary general meeting of the company within the period specified in subsection 4, and the requisition shall set out the matters. If the board does not within 21 days from the date of receipt of a valid requisition in regard to any matter proceed to call a meeting for the consideration of that matter on a day not later than 45 days from the date of receipt of such requisition, the meeting may be called and held by the requisitionists themselves within a period of 3 months from the date of the requisition. Now what it says? Somebody has made a requisition. Okay? Because section 100, subsection 2 talks of conducting of the meeting in pursuance to a requisition. So first of all, it says who can make the requisition. Okay. So there are different provisions for a company having share capital and not having share capital. Okay. Now, suppose requisition is received and still the board does not hold the meeting. Then what will happen? If the board does not, within 21 days from the date of receipt of a valid requisition in regard to any matter, proceed to call a meeting for the consideration of the matter on a day not later than 45 days from the date of receipt of such requisition. So what is the significance of 45 days? Can anybody tell me? Why they have written 45 days here? They have written 45 days because within 21 days they have to be active. Okay. Then 21 days notice is required and 21 days clear notice is required. So 21 will mean 21 plus date of receipt and date of dispatch. So 23 clear days. So 21 plus 23, 44. So if they do not hold within 45 days, meeting may be called and held by the requisitionists themselves. So if board does not comply, they made the requisition. Suppose board doesn't hold, then what is the right available with the requisitionists? So this is the provision. So they can call the meeting themselves. And a meeting under subsection 4 by the requisitionists shall be called and held in the same manner in which the meeting is called and held by the board. Okay? And any reasonable expenses incurred by the requisitionists in calling a meeting under subsection 4 shall be reimbursed to the requisitionists by the company, and the sum so paid shall be deducted from any fees or other remuneration payable to such of the directors who were in default in calling the meeting. Okay? Now the provision is clear. 100 section 100 is clear.
Yes,
Yes,
sir.
sir.
Yes, sir.
Very much clear.
हाँ. तो अब यहाँ देखिए, the board may, whenever it deems fit, call an extraordinary general meeting of the company.
A, sir.
Is
Yeah.
Okay. Now, next question. The notice of every meeting of the company shall be given to
If all of the above, F,
So,
Member. No. Committee,
all of the above.
representative.
any section for this? Section also
101, sir.
I think
101. 101, sir.
section 101. So let us see section 101 before we
Sir,
answer
what
this.
speaks about the assignee of the insolvent member?
भाई वही इसीलिए ना, let us see the section.
Okay, sir.
Section देखेंगे पता चल जाएगा.
Okay.
Let us see the section. This is 101. अब पर्दा उठ गया, देख लो क्या है, किस किस को भेजना है. सबसेक्शन 3 बोल रहा है. क्या बोल रहा है? Every member of the company, legal representative of any deceased member or assignee of an insolvent member, auditor or auditors of the company. So can there be more than one auditor of a company?
Yes, sir.
yes, sir.
Sometimes there is a concept of joint auditors. Every director of the company. Any, अच्छा, तो किस किस को भेजना है ये दे दिया. This is given in section 101 subsection 3.
3.
So section 101 subsection 3. Now what is the option?
F.
All.
F, sir.
All of the above.
F. Okay.
Yes, sir.
Now next question. A general meeting of the company may be called by giving not less than clear.
21 days.
Yeah.
21 days.
Yes.
C.
So answer is C.
C.
And what is the section for this?
101.
101.
A1.
101.
Subsection 1.
10.
Subsection 1.
Yes. 101 subsection 1. So hint also we can write section 101 subsection. Now next. Every notice of a meeting shall specify
All of the above, sir.
F. If
So
all of
same section, 101.
And section
101 subcross
101 subsection 2, sir.
subsection 2, it says every notice of a meeting shall specify the place, date, day, and the hour of the meeting, and shall contain a statement of the business to be transacted at such meeting. But they will not ask so simple questions. So they will ask a question like this: okay, which of the following need not be specified while giving the notice of the meeting? So can you tell me any option other than these? So they will not ask you simple questions like this. But you have to be clear about the simple questions so that you are aware about the provisions. Suppose you are an examiner and you have to frame a question on this. And the question should be like this, that which of the following should need not be specified while giving notice of a meeting? So what option will you choose? Can you think of any other thing?
Yes, sir. If they are changing the timing, sir, say they are giving odd timing, not between
No, no,
9
no,
to
no, no.
6.
Changing नहीं, changing. First meeting की बात हो रही है ना. Notice में क्या specific? What will you give in the options as an
Sir,
exam?
financial statements, sir.
No, वो statement of the business आ गया इसमें. Statement of the
No, to
business.
be transacted only, no, sir.
They're
Statement of
talking about
business to be transacted.
Yes, yes, you can give financial statements also. You can give the city also, because it is talking of place. And what is the meaning of place?
इसमें तो एड्रेस देना होगा ना पूरा,
Correct.
सिटी आ ही जाएगी उसमें तो.
है
प्लेस में तो एड्रेस देना होगा तो सिटी आ
तो
ही
क्या
जाएगी.
ऑप्शन क्या लोगे आप? इसके अलावा आपको कोई ऑप्शन देना है? कुछ तो हो सकता है ना.
कुछ तो
आप एग्जामिनर हो, ठीक है. Rajshekharan ji, you are an examiner and you are asked to set a question on this section, and you are asked कि भाई you must confuse the students, and you have to frame a question like this: which of the following need not be specified while giving notice of a meeting?
sir, in respect of place, sir.
नहीं, कुछ भी बता दो.
डिटेल्स ऑफ प्रॉक्सी वोटर्स या ऐसा प्रॉक्सी.
प्रॉक्सी वोटर तो अलाउ है.
हाँ, नहीं, प्रॉक्सी भी दे सकते हैं, राइट.
हाँ,
प्रॉक्सी फॉर्म. और क्या ऑप्शन हो सकता है? देखो, थोड़ा दिमाग चलेगा इस तरह से. और क्या हो
एलियन
सकता है?
कंट्री का बॉर्डर, कंट्री का बॉर्डर
मोड ऑफ मीटिंग, मोड ऑफ मीटिंग डिटेल्स.
नहीं प्लेस नहीं.
ओके, ठीक है. तो अब आंसर क्या हो गया इसका? तो आंसर एफ हो गया. सिंपल है तो, है ना. बट आपको थोड़ा सा ऐसे सोचना है. यू हैव टू थिंक ऑन दीज टर्म्स. सेक्शन क्या है? 1012 1012.
101.
101 subsection 2.
प्लस 2.
हाँ, ये सबसेक्शन 2 है ना.
Yes, sir.
हाँ, अब देखिए, इसका आंसर हो गया. मैं भी लिखता जा रहा हूं आंसर. इसका आंसर हो गया ई. नाउ,
Sir,
and what types of businesses are there which are to be specified in the notice?
स्टेटमेंट ऑफ द बिजनेस तो लिखा ही है
No,
ना.
no. What are there are two kinds of businesses which are to be discussed. So what are those two kinds of businesses? Special
Which
business
is
and
noted in
ordinary business.
memorandum, sir.
Special business and ordinary business.
हाँ, ये भी
And then you have to
confuse किया.
specify what is included in ordinary business, what is included in special business. उसका भी क्वेश्चन आता ही होगा. नेक्स्ट क्वेश्चन देखते हैं. Now a statement setting out the material facts concerning each item of special business to be transacted at a general meeting shall be annexed to the notice calling such meeting. Such a statement should include the nature of concern or interest, financial or otherwise, if any, in respect of each items of. So what is the option and what is the section?
Section 102, sir.
Section 102. Okay. So let us read the
Section 1.
let us read section 102. Statement to be annexed. Now 102 is visible.
Yes, sir.
जी
हाँ.
सर.
So a statement setting out the following material facts concerning each item of special business to be transacted at a general meeting shall be annexed to notice calling such meeting, namely the nature of concern or interest, financial or otherwise, if any, in respect of each item of every director and the manager, if any, every other key managerial personnel, and relatives of the persons mentioned in subclauses 1 and 2. Any other information and facts that may enable members to understand the meaning, scope, and implications of the items of business and to take decisions thereon. Okay. And then special business and ordinary business. So this is given in subsection 2. But now I think our question is based on section 102, subsection 1. Let us go back to our question. This was the question. Now what is the answer?
Option
ए
E.
बी तो ठीक है सर, ए
E, sir.
बी
हाँ?
E.
ए एंड बी बोथ आर करेक्ट.
अच्छा, सी करेक्ट है कि नहीं?
C is also, but
C
it is not
C
specifically
भी तो
mentioned
correct है.
as 1 and 2.
और डी भी करेक्ट.
Person concerned.
Sir, E option
E,
will be
sir.
the correct.
हाँ,
E is the
ये
option,
ऑप्शन
sir.
होगा. हाँ,
ये ऑप्शन है.
अभी तो पढ़ा. Now next, in the case of a public company, 5 members personally present if the number of members as on the date of meeting is not more than 1000 is sufficient quorum. 15 members personally present if the number of members is not more than 1000. So क्या होगा quorum? In case of a public company, so there is a specification regarding quorum. And suppose the number of members is not more than 1000, then what is the quorum? This is the question precisely.
Not more than 1 means 5 members, sir.
Okay. Any section for this?
Yes, sir. 103, sir.
103.
103 A.
Clause A, subclause 1.
Subsection 1.
Right.
Clause A, sir.
Mhm.
Clause A.
So
Subclause
section 103 subsection 1 subclause 1. है ना? So in the case of a public company, 5 members personally present. If the number of
Sir,
members
clause A, subclause, sir, 101, subsection 1, clause A, subclause 1.
right.
One.
A is also to be given. Right. Yes. Now it is correct. So this is the option. Now, if we ask you if 3 members are personally present and there are proxy forms for 2 members, then whether it will be valid quorum. They can ask you a question like this. 3 members are personally present and there are proxy forms for 2 members. Then whether it will constitute a quorum or not.
No, sir. Because 5 members personally present.
Yes. And who will decide the quorum? भाई quorum कोई decide भी तो करेगा कि अपने आप
Chairman.
Basically, the chairman of the meeting. That's the quorum.
Chairman.
Chairman of the company.
And chairman generally is an independent director. So although there are different provisions, but generally an independent director is made the chairman of the meeting. Now,
it can also be provided in the articles, no, sir. It can be also provided in the articles, no, sir.
Maybe. So 15, what was the answer here? In 15, A? A was the answer. Okay. Now 16. In the case of a public company, so if it is more than 1000, then how many members?
15 members.
15 members, sir.
Up to 5,000, 15 members.
So what I will do is, I will copy this.
Sir, in the previous question that I couldn't get you that 3 members physically present and 2 proxy, then quorum will not be constituted, no, sir?
No. Quorum will
Quorum
not
will be. Okay, sir. Okay.
Because personally present.
Okay, personally. Okay.
Just a minute. Hello, good morning जी, how are you? हाँ जी बताइए. So here the answer will be B. 15
B.
members.
Yes, sir.
So answer is B. 15 members
Yes,
personally present. नहीं ये क्या बोल रहा है? Up to 5,000.
Up to 5,000. Up to 1,005. 5,000 to 15,000.
5,000.
To 15 members.
Hmm.
Above 15, 30 members. Above 5,000, 30 members.
तो ये हो गया आंसर आपका, है ना? इसका आंसर हो
Correct,
गया बी. बी हो गया ना? Now
Yes,
next.
sir.
In the case of a public company, now it is talking of 16 तो हो गया था ना हमारा.
Yes, sir.
17. देखिए अब देखिए. If it is more than 5,000 तो कितना होगा?
C.
30 members.
30.
Okay.
Lost.
नहीं बढ़िया है. देखो ऐसा है, सबसे बड़ा बेनिफिट तो मुझे हो रहा है, मुझे खुद भी याद हो जाएंगे. याद तो नहीं होंगे खैर, लेकिन ये है कि चलो कुछ तो याद रहेगा. ये हो जाएगा 3.
Three.
तो आंसर विल बी सी. ओके.
C.
नेक्स्ट. In the case of a private company, what is the quorum?
D, sir.
दो
Two,
आदमी.
two members. Two.
2 members.
So D will be the option.
Yes.
Yes, sir.
2 members.
2 members personally present shall be the sufficient
Yes.
quorum.
So this is given in 103 1B.
B. Yes, sir.
Yes, sir.
It is B. And we can remove this. Now next question. 19. If the quorum is present, not present within half an hour from the time appointed for holding a meeting of the company, तो क्या होगा?
Yes, sir. It will be stand adjourned
B.
to the next week at the same day,
Cancel.
same time,
Will be cancelled.
same place. Yes, sir.
A.
But let us read the provision. Let us go to the section. I think better clarity
sir.
will be there. So
Section
103.
103 subclause 2. A.
Subsection.
Subsection.
Yes, sir.
Subsection 2 subclause A.
103. Now
Clause
please
A.
read this. So it says, if the quorum is not present, the meeting shall stand adjourned to the same day in the next week at the same time and place, or the meeting, if called by requisiteness, shall stand cancelled, provided that if in case of adjourned meeting or of a change of day, time or place, the company shall give not less than 3 days notice to the members either individually or by publishing an advertisement in the newspaper, one in English and one in vernacular language,
Vernacular.
which is in circulation at the place where the registered office of the company is situated. And if if at the adjourned meeting also a quorum is not present within half an hour, the members present shall be the quorum.
Order.
So this is the provision. Now let us go back again to our study. Now please answer.
Means D answer.
D, sir.
D will be answer. All the above.
All the above, sir.
Yes.
All of the above.
Because after reading the provision, now you had a change of mind.
Yes, sir.
Yes, sir.
Correct, sir.
You know? So now it is D, all of them. And the section related is 103 2.
Subsection 2, sir.
नहीं देखो ऐसा है कि भाई these are very not very complicated thing, but you have to remember a lot.
Yes.
So if you keep on repeating this thing, na, so there is a purpose behind this recording also. So recording you can, suppose you are sitting in a toilet or you are just walking on the road. So you can keep, you are sitting in the car, so you can listen to the recording.
Yes, sir.
Yes, very useful, very useful. Yes.
So now, if at the adjourned meeting, a quorum is not present within half an hour,
D answer. The members present shall
D.
form the quorum.
Shall form the quorum. D.
D will be the answer, sir.
Section 103, subsection
Subsection 3.
3.
Section 3, yes, sir.
The question seems to have repeated, huh?
Yes, it seems to be repeated.
कौन सा? ये वाला?
19 और 20
first one,
दोनों आपस में मिलजुल रहे हैं.
ये वाला और दूसरा? नहीं नहीं, इसमें क्या बोला है? इसमें ये नहीं बोला. ये 3 पर बेस्ड है. A quorum is not present, then the members present shall be the quorum.
Within half an hour.
It is talking of quorum only.
एडजॉर्न मीटिंग में लोग नहीं आते हैं तो ठीक है?
हाँ. तो इसका आंसर क्या होगा? डी.
जितने लोग प्रेजेंट होंगे उसी से quorum हो
D,
जाएगा.
sir. The members
for
present
delete.
shall form the quorum.
Yes, I think answer should be D because it is based on
Yes, sir.
section 103, subsection 3.
Subsection 3. Yes, sir.
It is talking of quorum only, not of other things.
Yes, sir.
Actually, in day-to-day life, we are not dealing much with these things, no?
Sir, actually, that is meeting and this is adjourn meeting, sir.
Yes, right. Like take our case, we handle our this company matters. They are handled by a company secretary only, so we don't deal into these things. They are directly billing to our clients.
आईबीसी में तो यही वाला लास्ट वाला क्लॉज ही लागू है ना.
हाँ, सभी में
आईबीसी के हर मीटिंग में ये लास्ट वाला क्लॉज ही मीटिंग लागू. नेक्स्ट डे ये.
हाँ, अब चलिए. The chairman of the meeting will be elected through 104, section 104. Let us read first 104. Then I think better clarity will come.
All of the above things.
Section 104, chairman of the meeting. Now this is the provision. Unless the articles of the company otherwise provide, the members personally present at the meeting shall elect one of themselves to be the chairman thereof or on a show of hands. So the articles may provide that, okay, such and such person will be the chairman. But now 104 says, if the articles do not provide, unless the articles otherwise provide, the members personally present at the meeting shall elect one of themselves to be the chairman thereof on a show of hands. And if a poll is demanded on the election of the chairman, it shall be taken forthwith in accordance with provisions, and the chairman elected on a show of hands shall continue to the chairman of the meeting until some other person is elected as a chairman as a result of the poll, and such other person shall be the chairman for the rest of the meeting. So, what could be the different scenarios for election of chairman? Number 1, provision in the articles. Number 2, members personally present, electing on a show of hands. Third is through poll. So if a poll is demanded, suppose people do not agree, there are 5,000 people and then they are not clear as to who raised his hand or in favor or against. So they can demand a poll also. So when they are demanding a poll, so the person selected as a result of the poll shall be the chairman for the rest of the meeting. So another question out of this, whether there could be 2 chairmen in the same meeting, the answer will be yes. Because initially, when the meeting started, Mr. X was the chairman. Why Mr. X was the chairman? His name was given in the articles, or the members personally present, they elected him as the chairman. But then another person objected to it, and he said that, okay, things are not clear, I am not satisfied, and you please conduct a poll on this. And then poll was conducted and another person was elected as the chairman. So he will be the chairman for the rest of the meeting. So this wording for the rest of the meeting itself shows that there could be more than one chairman. And they frame questions like this only. They will not ask you simple questions.
Yes, sir.
So Now what is the answer?
All of the above.
All of the above. D.
Hmm. And the section is
Section 104.
section 104. We can simply write section 104. Now next. And option in 21, 20, 20. This was D option 20 and 21 and 20 में क्या option था?
20 में D, sir. D for Delhi.
Acha, D for Delhi. Yes. Now next. 22. The central government may prescribe a class or classes of companies whose members shall not be entitled to appoint another person as a proxy.
True, sir.
True? Okay. And
Yes,
what
sir.
is so 105.
Section 105.
Section 105. It is on proxies.
5.
So it says any member, but let us read this section. So please make it a point to read the entire section because
Okay, sir.
more questions could be set on this.
Hmm.
So 105. It is regarding proxies. And this is the section. Any member of a company entitled to attend and vote at a meeting of the company shall be entitled to appoint another person as a proxy to attend and vote at the meeting, provided that a proxy shall not have the right to speak at such meeting and shall not be entitled to vote except on a poll. Provided further that unless the articles of a company otherwise, now there could be one question out of this with this saying a proxy shall not have the right to speak at such meeting and shall not be entitled to vote except on a poll.
Hmm.
Provided further that unless the articles of a company otherwise provide, this subsection shall not apply in the case of a company not having a share capital. So it says if the company is not having a share capital, then provisions will not apply unless the articles otherwise provide. Okay? Provided also that the central government may prescribe a class of classes of companies whose members shall not be entitled to appoint another person as a proxy. Provided also that a person appointed as proxy shall act on behalf of such member or number of members not exceeding 50. This is also important. So a member can hold proxy for members not exceeding 50 and such a number of shares as may be prescribed. So it says number of members should not exceed 50 and number of shares. Now what is prescribed is given in the rules. These are the rules. A person can act as proxy on behalf of the members not exceeding 50 and holding in the aggregate not more than 10% of the total share capital of the company carrying voting rights. Provided that a member holding more than 10% of the total share capital of the company carrying voting rights may appoint a single person as proxy and such person shall not act as proxy for any other person. So can anybody tell me the implication of the second point? Second proviso to the rule. Can anybody explain? What is the meaning?
Yes, sir. Sir, a member not holding more than 10% cannot vote, act as a proxy, sir. So if it is one person means then that only one, sir. He can act on the behalf of one person.
Actually, I'll explain it by way of an example. Mr. X is a shareholder. He is having, say, 20% share capital of this company. Now, Mr. X, who is holding more than 10% of the total share capital of the company, which is carrying voting rights, he may appoint a single person as proxy. Okay? And now suppose Mr. X appointed Mr. Y as a proxy. Okay? But now this Mr. Y, he will not act as proxy for any other person or shareholder. Because what we read, a person can act as proxy for members not exceeding 50. But if there is a single shareholder which is holding more than 10% and he is appointing a person as proxy, then that number of 50 will not apply. In that case, he will be acting as proxy only for a single member. This is the meaning. I hope it is clear.
Yes.
So here, what is the answer?
Yes, sir.
ये तो ए हो जाएगा. ठीक है. 22 का ये हो गया. Now 23. A person appointed as proxy shall act on behalf of
All of the above, sir.
All of the above. All of the above.
so 20.
B sir, B sir,
हाँ?
B लग रहा है सर, B.
B sir.
B होगा D होगा.
D, sir. Delhi, sir.
D Delhi.
अभी पढ़ा ना हमने, एक बार दोबारा पढ़ लीजिए,
नहीं तो A और C रहना चाहिए सर.
एक बार देख लो, ये देख लो क्या बोलते.
Proviso, sir. Proviso 4. Provider.
सर अगर दो आदमी हैं सर, ए और बी, सर ए के पास 12% का शेयर है,
अब
बी
देखो
के पास
इसमें पता कौन सा प्रोवाइजो है. जस्ट अ मिनट. 1 2 3 4 प्रोवाइजो 4 है. 105 का, एक मिनट, आई विल टेक यू टू द प्रोवाइजो 4.
पूरा लग रहा है एकदम.
जस्ट रीड सेक्शन 105 प्रोवाइजो 4.
8 साल का हुआ है.
प्रोवाइजो 4 क्या बोल रहा है? ये है प्रोवाइजो 4. Provided also that a person appointed as proxy shall act on behalf of such member or number of members not exceeding 50 and such number of shares as may be prescribed. So the question is based on fourth proviso, because this is first proviso, second proviso,
Yes,
third
sir.
proviso, fourth proviso. So
Fourth
section
proviso.
105 fourth proviso. We can say fourth proviso.
Sure, 4. Yes, sir.
Fourth proviso. So now what is the answer?
D. All
D,
of the above.
D, all of
D,
the above.
right. Now,
All
next,
of the
companies shall be, so I think we can continue up to 10 o'clock, है ना? Because 10 o'clock I have
Yes,
to
sir.
go somewhere. So company shall be entitled to appoint another person as a proxy to attend and vote at the meeting on his behalf, provided that a proxy shall not have the right to speak at such meeting and shall not be entitled to vote except on a poll.
सर मेरा
sir.
कंफ्यूजन था सर.
True sir.
सर
Yes, please.
वो मेरा कंफ्यूजन है कि दो आदमी हैं ए और बी, ए का शेयर 12% है और बी का 13%.
ठीक है. हाँ तो दोनों एक एक प्रॉक्सी करेंगे. सेम पर्सन
एक-
प्रॉक्सी नहीं हो सकता.
एक ही आदमी वो कर सकते हैं क्या?
नहीं 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 कर सकते, नहीं कर सकते. लिखा है ना, वो एक ही करेगा और वो किसी दूसरे के लिए प्रॉक्सी एक्ट नहीं करेगा.
ठीक है सर, ठीक, क्लियर सर, क्लियर.
Suppose now Mr. X is having say 15%, Y is having say 16%. Now X can appoint one proxy, say Z, and Y may, but Y cannot appoint Z.
क्लियर सर, क्लियर.
हाँ, इतना ही है. And now this section 105.
Right? Proviso 1, sir.
A member of the company. I think this question is wrongly worded. It should be a member of the company.
And already it is true, sir. Already, as we discussed.
Member of the
Right to
company
speak.
should be the correct, sir.
Huh?
Yes, sir. Yes, sir. Yes, sir. Member of the company.
So we can say and what is the section or subsection or proviso?
Proviso 1, sir. 105 Proviso 1.
Proviso 1. It says, provided that a proxy shall not be entitled. Okay. So any member of the company. It should be any
Yes,
member
sir.
of the company.
Member of the company. Yes, sir.
Any member of the company shall be entitled to appoint another person as proxy to attend and vote at the meeting on his behalf, provided it. So now it is correct. So this is 1051.
Proviso 1. Yes, sir.
Proviso 1. Proviso 1. First proviso. Rather, we
Yes.
call it like this. We call it first proviso. First proviso.
Sir.
So, answer is
Subsection 1, sir.
A, true.
A is the
Ah.
answer.
Subsection proviso. First proviso 105 1.
Subsection 1.
So we can write like this.
Provision.
Now, next question. A member entitled to attend and vote at a meeting of the company which has a share capital or the articles of which provide for voting by proxy at the meeting is entitled to appoint a proxy or proxies to attend and vote, and that a proxy need not be a member.
True.
Now it is talking of which case?
True,
It
sir.
is talking of a company which is having share capital or the articles of which provide for voting by proxy at the meeting. So in that case, he is saying that a member is entitled to appoint a proxy or proxies
Not be a member.
to attend and vote, and that a proxy need not be a member.
True, sir.
And what is the exact section?
105 subsection
105
2.
subsection 2.
105 subsection 2.
No, sir. No, sir. It's proviso 21051 only.
No, it is section 105 subsection 2, I think.
True. Yes, sir.
But now another question emerges out of this. So whether now Mr. X is a shareholder. Mr. X is having, say, 9% share capital. So can he appoint two proxies? One say for 4%, another for 5%. Can he appoint? Or he has to appoint only one?
No, sir. We cannot do it.
Only
He
one.
can appoint.
Only one.
No, he can do it. He can do.
He can do. It's mentioned to appoint a proxy or proxies to attend
Yes.
the.
बोलेगा ना मैं दोनों स्वाद लूंगा भाई क्या बोलता in every notice calling a meeting of a company which has a share capital or the articles of which provide for voting by proxy, there shall appear with reasonable prominence a statement that a member entitled to attend and vote is entitled to appoint a proxy, or where that is allowed, one or more proxies to attend and vote instead of himself, and that a proxy need not be a member. So it is envisaging a situation where there is a shareholder, he has got say 9% share capital. Now for 4%, he appoints proxy 1, and for 5%, he appoints proxy 2. So that is allowed. Because
Sir, why, what is the reason behind this, sir?
the reason behind
Why?
it, that actually he wants to sell in the same more than one boats, because two boats are going, so he wants to reserve the seats in both the boats.
Okay.
Huh? Sometimes you book an air ticket for 4 flights, so that if I'm not able to go in the first flight, I'll go in the second flight. So
Fine, sir.
those people who are busy, what they do, they book all the flights on a particular day, and depending upon their convenience, they will go. So it is saying,
Can he appoint more than two also, sir? Can he appoint
Yes.
more than two also?
Yes.
बिल्कुल क्यों नहीं?
Yes.
One or more है, more could be 100. Theoretically, one or more proxies.
नहीं तो मान शेयर मान लीजिए उनका 10 है तो उसी को बांट सकते हैं क्या?
बिल्कुल बांट सकते हैं, क्यों नहीं बांट सकते?
नहीं, एक अगर आर्टिकल से हो और एक से ऐसे हो तो उसका अलग अलग दोनों का
भाई
कर
देखिए
दीजिए
ऐसा
या
है,
एक ही पार्ट को
every share has got a distinctive number, and in the proxy also you have to write the distinctive numbers. If you go through the proxy form, so I think we can have a look at the proxy form also. Proxy form देख लेते हैं. देखो ऐसा है, examiner is asking very tricky questions.
एग्जामिनर किधर आते हैं उनको ढूंढना है हम लोग.
अरे बहुत सारे तो मेरी टच में हैं.
तो उनसे पूछ के बता दीजिए ना सर.
Most of them are my students only.
अरे एग्जामिनर तो हमारा सामने बैठा है, गुप्ता जी स्वयं एग्जामिनर
No, 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 I am not an examiner. No,
तो
no.
एग्जामिनर लोगों के एग्जामिनर है वो.
ये है फॉर्म नंबर MGT 11 प्रॉक्सी फॉर्म. देखिए प्रॉक्सी फॉर्म क्या बोलता है. इज इट विजिबल और नॉट?
Yes,
ठीक
sir.
है, थोड़ा सा और बड़ा हो जाए तो अच्छा है सर.
हाँ बड़ा हो जाएगा. लीजिए हो गया
हाँ
बेटा?
ठीक है, हाँ क्लियर है, ठीक है सर।
अब देखिए क्या क्या बोलता है इसमें, आपको क्या देना है। देखो देखो 3 नाम दे दिए ना, बोल दिया ये नहीं आए तो ये हो जाएगा, ये नहीं आए तो ये हो जाएगा,
ये परसेंट तो अलग नहीं दिया ना इसमें,
है?
मैंने हमारे 10 शेयर का ये होगा, 5 शेयर का ये होगा, ये सब तो कुछ नहीं है ना।
अरे वो भी हो जाता, ये तो एक ने दिया ना, वो तो प्रॉक्सी अपने आप वोटिंग करेगा ना, इसमें क्या देना है उसको, वो तो प्रॉक्सी वोटिंग करेगा।
इतना शेयर के लिए हम प्रॉक्सी हैं ऐसा कहीं मेंशन
Sir,
अगर
but it is saying if he is not failing him.
No,
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 ma'am, what your Shailesh is telling that if there is a 50 share is there, so can he put the proxy voters? That is what he is saying. I mean,
Here, yeah, correct, but here it is saying only
no, no, but
first person failing, second
no,
person failing.
this is just a format. We have to read as per the provisions which are
yes sir,
given in
yes
the
sir,
code.
yes.
yes.
So the provisions do not say like this. They say one or more proxies. Now, what is the meaning? So you have to take the natural meaning. The natural meaning of that will be that, okay, more than one proxies can be appointed. But now we are going a step further. So whether he can bifurcate his shares and say that, okay, for such and such percentage, this will be the
Yes sir, yes.
point is here.
Yes.
But suppose he can appoint, say, 3 proxies. Take it.
Mm.
Now, whether one only will be allowed or all the 3 will be allowed, this could be another question.
Mm.
Because in this case, he says, or failing him. Suppose Mr. 1 doesn't fail, then whether second will be allowed, the answer will be no.
Mm.
He says, what he means to say is, if he doesn't turn up, suppose he doesn't turn up, then he said, okay, you allow second person. If second person also doesn't turn up, then you allow third person.
ऑप्शनल दे दिया है, yes, right.
हाँ. So, as a matter of interest, you can consult some good company secretary. So, you will be able to throw better light on this.
Okay, sir.
So, अच्छा ये हो गया हमारा क्वेश्चन. अब चलते हैं.
Normally, we don't come across such a situation, sir.
No, but actually law allows all types of law takes care of all types of situations, na? And as an examiner will ask you definitely a difficult question. They will not ask you a normal question. They will ask you a question where you could be in a fix, where you could be in a doubt.
Yes, sir.
So here, what is the option?
True.
Okay.
C.
Yes.
Next question. We will try to close this management and administration. I think there are 67 questions. So let us be quick. If default is made in complying with subsection 2 of section 105, every officer of the company which is in default, what is the penalty? So let us go quickly to the penalties. 1052. If default, shall be liable to penalty of 5,000 rupees. So this is given in 3. 1053. Section 105, subsection. So what is the answer?
C, sir. Sorry, B 5,000.
B for
B,
Bombay.
sir.
सर जी आंसर दिखा दिया, उसके बाद भी गलती कर रहे हो, फिर क्या आपके सामने बुक खोल दिया. बताओ. द इंस्ट्रूमेंट अपॉइंटिंग ए प्रॉक्सी शैल बी
All of the above. D.
D.
D. All of the above.
Let us see the provision. What it says.
1056.
The instrument appointing a proxy shall be in writing and be signed by the appointer or is a nominee, duly authorized in writing, or if the appointer is a body corporate, be under its seal or be signed by an officer or an attorney, duly authorized by it. So, this is the meaning. And an instrument appointing a proxy, if in the form as may be prescribed, shall not be questioned on the ground that it fails to comply with any special requirements specified for such instrument by the articles of the company. Now, what is prescribed? Let us see the rule. The appointment of the proxy shall be in form MGT 11. Form भी पूछ सकता है आपका.
Yes, sir.
चलिए, तो क्या आंसर हो जाएगा इसको? ऑल ऑफ द अबव,
Yes.
है ना?
Yes, sir.
हाँ 20. बट आप ये देखो, these are simple questions. They will ask you much more difficult questions. But you have to first go through these questions. You take it as a base for understanding Companies Act. And once you understand the provisions, then you frame your questions on your own, and then you write in the group. Because the name of the group is serious about IBC. So you have to frame your own questions, and which are much more difficult than the questions which are given in the case study. Now next. 28. A company shall not prohibit any member from exercising his voting right except on the grounds. Let us go to section 106 before we answer this question.
Both A and B. Both.
So 106. This is 106. What it says. Notwithstanding anything contained in this act, the articles of the company may provide that no member shall exercise any voting right in respect of any shares registered in his name, on which any calls or other sums presently payable by him have not been paid, or in regard to which the company has exercised any right of lien. So what is the meaning?
fully
The
paid
meaning
नहीं
is-
है अगर.
Meaning is
Agreed.
that articles of the company may provide that, okay, if some money is not paid, then he cannot exercise the voting right. So voting right is exercised only on the basis of paid up capital.
Okay.
And suppose some calls have been paid in advance, then whether he will get the voting right for those calls paid in advance or not.
No.
No, sir.
Right. A company shall not, except on the grounds specified under subsection 1, prohibit any member from exercising voting right on any other ground. Okay. On a poll taken at a meeting of the company, a member entitled to more than one vote or his proxy where allowed, or other person entitled to vote for him, as the case may be, need not, if he votes, use all his votes or cast in the same way all the votes he uses. So this also partially supports my stand that, okay, he can vote in different manner. What he says, if he votes, use all his votes or cast in the same way all the votes he uses. Because a member is entitled to more than one vote. Okay?
You can't say one yes and one no. All yes.
Right.
Or all no.
Right. Just a minute. Hello, Anji. Now, yes. So, on a poll taken at a meeting of a company, a member entitled to more than one vote or his proxy, where allowed, or other person entitled, as the case may be, need not, if he votes, use all his votes or cast in the same way all the votes he uses. Okay?
इसका मतलब कास्ट इन द सेम मींस
मतलब ये है कि जैसे मर्जी यूज करे, उसके बाद 100 वोट हैं, 100 वोट में 50 फेवर में वोट करे, 50 अगेंस्ट वोट करे.
इससे अच्छा कि वोट नहीं करे, बराबर हो जाएगा सर.
नहीं, 40 फेवर में कर दे, 60 अगेंस्ट कर दे.
ठीक है.
20 फेवर में कर दे, 80 अगेंस्ट कर दे.
बिल्कुल.
दोगला है सर.
है नहीं, दोगला की बात नहीं है। देखो ऐसा नहीं है, पता क्या होता है, सपोज देयर इज ए जॉइंट शेयर होल्डिंग। देखो हमें क्या लॉ को पढ़ना है, लॉ को हमें सीरियस होके पढ़ना है।
बिल्कुल बिल्कुल।
थिंक ऑफ सिचुएशंस।
Yes, sir.
सपोज देयर इज ए जॉइंट शेयर होल्डर, ठीक है भाई, ए सिंगल डिस्टिंक्टिव नंबर is having a joint shareholder, so joint shareholding is also allowed, ठीक है। Now there are Mr. A and Mr. B, they are joint shareholders of 100 shares. Now Mr. A is in favor of the resolution and Mr. B is against the resolution, so and they are appointing the same proxy, they can appoint, because one
Yes.
person can be a proxy for 50 members, तो इस तरह से एक्सरसाइज कर सकते हैं।
तो 50 मेंबर्स का हो सकता है, शेयर का नहीं ना, 50 मेंबर्स का सर, यही ना।
अरे मेंबर तो देखो ऐसा है, सपोज मिस्टर ए एंड मिस्टर बी, दे आर होल्डिंग 100 शेयर्स इन ए कंपनी, ठीक है। नाउ दोज 100 शेयर्स हैव गॉट देयर डिस्टिंक्टिव नंबर्स, ठीक है। एंड हाउ वोटिंग इज डन, वोटिंग इज नंबर वाइज, डिस्टिंक्टिव नंबर वाइज। So he will say that for distinctive numbers 1 to 50, I am voting in favor of the resolution because he has been instructed so by Mr. A. And for distinctive numbers 51 to 100, he is voting in against the resolution because he has been instructed so by Mr. B. I hope now I am able to make my point clear.
Yes sir, yes sir, clear.
Yes.
In case of joint shareholding, it will happen.
Yes, we have to think of the situations, ना बस ये और क्या।
Hmm.
अब मुझे भी अभी मेरा भी क्या होता है, मेरा भी नेत्र तभी खुलता है, मतलब ज्ञान चक्षु तभी खुलता है व्हेन आई एम इन अ मीटिंग, बिकॉज आई हैव टू थिंक ऑफ सिचुएशंस। मेरे को भी पहले थोड़ी आता, अभी मैंने बनाया है सिचुएशन। इस तरह से हो सकता है, देयर कुड बी सिचुएशन लाइक दिस, सो वी हैव टू थिंक इन द सेम वे।
Hmm.
सो क्या होगा इसमें, इसका आंसर क्या होगा 28 का?
A and B. C, sir.
अच्छा, a company shall not prohibit any member from exercising his voting right except on the grounds articles of the company may provide that no member shall to the company's exercise. ठीक है, so his answer is C. Now next question. A member entitled to more than one vote or his proxy or any other person entitled to vote for the member need not, if he votes, use all his votes or cast in the same way all the votes he uses. अभी तो पढ़ा है,
ट्रू होगा, डी होगा सर।
True होगा,
हाँ।
sir.
True, true.
डी हो जाएगा।
106, subsection 3.
हाँ, 106 सबसेक्शन
3.
हाँ 3, ठीक है। अब मैं क्या करता हूँ, मैं सारी बुक्स मंगा लेता हूँ। अब मैंने ये कंपनी जैक्ट नया मंगा लिया, कंपनी जैक्ट तो ये 2023 का, तो मेरे पास पुराना था, बट मैं क्या है, पुराने वाले को यूज नहीं करता, आई ऑलवेज यूज द लेटेस्ट वन।
What is the author's name?
हाँ जी,
Sir, author's name. What is the name of the author of that?
no, it is a bare act only, taxman's company act with rules. So it is gutka type book, this is called gutka.
Okay, sir.
And besides that, I've got this guide to companies act by Ramaiah also, which is a detailed commentary.
Okay.
So I made a library of books in the office. So there is a library.
Okay.
Although I don't read much, but impression पड़ता है ना, पढ़ा लिखा आदमी है, चलो भाई, मतलब he is a literate person. So I try to give that impression that okay, he is a knowledgeable person. He is having so many books.
Sir, you need not give any impression, sir. You are brilliant.
Sir, like you people means
You are
India,
itself a book,
India,
sir.
India.
सर आप अपने आप में लाइब्रेरी हैं सर।
Yes, you are itself a book, sir.
At any general meeting of the company, a resolution put to the vote of the meeting shall be decided on a show of hands.
True.
What is the answer? So let us go to section 107.
109. Show up.
ये है ना, at any general meeting, a resolution put to vote shall, unless a poll is demanded under section 109 or the voting is carried out electronically, be decided on a show of hands. A declaration by the chairman of the meeting of the passing of a resolution or otherwise by show of hands and an entry to that effect in the books containing the minutes of the meeting shall be conclusive evidence of the fact of passing of such a resolution, because sometimes they are challenged in court when the stakes are high, when there are rival parties, so they will challenge the meeting. So it says that okay, if the chairman has entered in the books, so it will be deemed to be conclusive evidence. So now let us answer the question.
Two, sir.
True.
B for Bombay.
नहीं तो ए भी तो हो सकता है.
A.
दोबारा पढ़ो ना, दोबारा पढ़ो.
Yes, sir.
ए होगा आंसर इसका. देखो क्या बोल रहे हैं.
Yes, sir.
At any general meeting, a resolution put to vote unless a poll is demanded under section 109 or the voting is carried out. तो 109 क्या? 109 भी पढ़ लो. ये 109 है.
Demand of poll.
है ना जी. तो इसका आंसर जो है क्या होगा?
A.
ए होना चाहिए मेरे हिसाब से. तो भाई लिख दिया ना उसमें,
Section 107, subsection.
unless a poll is demanded, है ना. बिल्कुल क्लियर लिखा हुआ 107 में. दोबारा दिखा देता हूँ. ये 107 है.
Subsection 1.
हाँ 107 पे चलते हैं दोबारा. इसका पीछे वाला ये 107. Unless a poll is demanded or the voting is carried out electronically. तो तीनों ऑप्शन हो गए ना. तो इसमें चलते हैं हम लोग. ये हो गया है ना. तो आंसर इसका ये होना चाहिए मेरे हिसाब से. तो चलो 31 देखते हैं. 31 क्या बोलता है? एट एनी जनरल मीटिंग ऑफ द कंपनी a resolution put to the vote of the meeting shall be decided on a show of hands.
Sir, show of hands तो सबसे पहले तो वही अलाउड है सर. If that is not there, then we go for polling or something.
हाँ हाँ
तो show of
तो
hands
नहीं आंसर वो तो ठीक है. ऑप्शन देना ना, कौन सा ऑप्शन सही है.
यही सही रहेगा ना. पार्टी
A will be the right answer.
पढ़ लेते हैं दोबारा 107 क्या बोलता है. At any general meeting, a resolution put to vote at the meeting shall, unless a poll is demanded or the voting is carried out, be decided on a show of hands. So first is show of hands, then by poll, ठीक है, or voting is carried out electronically. So there can be three means. Number one, show of hands. Number two, electronic voting. Third is poll as per section 103. So what could be the various types of voting? Three types of voting. First, show of hands. Second is electronic voting. Third is poll as per 109. तो क्या आंसर होगा इसको? ए हो जाएगा.
ए हो जाएगा सर.
ये आंसर हो जाएगा. अब देखिए नेक्स्ट देखिए. A declaration by the chairman of the meeting of the passing of a resolution or otherwise by show of hand. अभी हमने देख लिया. And an entry to that effect in the books containing the minutes of the meeting shall.
Sir, give a conclusive evidence.
Conclusive evidence.
So answer is A.
A. Subsection 2.
33. Because if you read the case laws on Companies Act, now, particularly during valuation, these resolutions are challenged in the court of law. So then these provisions, they come into play. Section 33. The central government may prescribe the class or classes of companies and manner in which a member may exercise his right to vote by the electronic means. So 108. Before answering this question,
108.
let us read 108.
Yes, sir.
108. So this is the central government may prescribe the class or classes of companies and the manner in which a member may exercise his right to vote. And what is prescribed? This is the prescription. ठीक है. Voting through electronic means. तो जो ज्यादा डिफिकल्ट एग्जामिनर होगा वो इसमें से पूछ लेगा. Because they are also in your syllabus.
सर आप एग्जामिनर को क्लू मत दीजिए सर. वो इससे पूछेगा तो it will be difficult for us then.
नहीं, कुछ क्वेश्चन बना के उनको दे दीजिए सर, जो हम लोग को भी मालूम रहे.
तो सेंट्रल गवर्नमेंट में प्रेस्क्राइब. ठीक है ना. ये तो ट्रू हो गया. सिंपल क्वेश्चन है. नेक्स्ट क्वेश्चन देखिए. द चेयरमैन ऑफ द मीटिंग may on his own motion or on a demand made in that behalf, order a poll at the meeting on such resolution as he thinks fit and proper. तो 109 पढ़ लेते हैं एक बार इससे पहले. 109 क्या बोलता है? ये हमारा 109 है. ठीक है. Before or on the declaration of the result of voting on any resolution, a poll may be ordered to be taken by the chairman. ठीक है. वो 1/10 हो गया और ये वाला हमने पढ़ लिया था 109. Demand for a poll may be withdrawn at any time by the person who made the demand. ठीक है. तो हमारा कहाँ था आंसर इसमें? एक बार क्वेश्चन दोबारा पढ़ते हैं. क्वेश्चन ही भूल गए क्या क्वेश्चन था. क्वेश्चन ये था, द चेयरमैन ऑफ द मीटिंग may on his own motion or on a demand made in that behalf order a poll at the meeting on such a resolution as he thinks fit and proper. Chair, so there was some connection issue. ये तो यहाँ चेयरमैन की बात कहाँ करते हैं?
फर्स्ट लाइन में है सर, बाय द चेयरमैन ऑफ द मीटिंग सेक्शनों में.
नहीं ये सेक्शन मेरे को तो लग रहा है सेक्शन ही गलत दे रखा है यहाँ. ये देखो जरा क्या बोल रहा है. पहले क्वेश्चन पढ़ो. द चेयरमैन ऑफ द मीटिंग में इसका सेक्शन बताओ पहले. तो सेक्शन क्या होगा?
Same sir, 109 1A.
109
109 सर,
First line itself.
फर्स्ट लाइन इटसेल्फ सर.
हाँ ये 1091 है. ठीक है. द चेयरमैन ऑफ द मीटिंग ऑन हिज ओन मोशन एंड शैल बी ऑर्डर टू बी टेकन बाय हिम ऑन अ डिमांड मेड इन दैट बिहाफ. ठीक है. नहीं ये बात कहाँ लिखी है कि थिंक फिट्स एंड प्रॉपर लिखा गया? तो हैव दे रिटन एनीवेयर? ये वर्ड जो है एज
No,
इन
sir.
फिट एंड प्रॉपर.
No, sir. Fit and proper.
No,
is not.
sir.
So 1091 only is talking of this thing, and 1091 is saying, just a minute. नाइनटीन में क्या है? सेक्रेटेरियल स्टैंडर्ड है और जनरल मीटिंग. वो सेक्रेटेरियल स्टैंडर्ड में लिखा होगा. एक मिनट अभी देखते हैं. ये है ना, यहां पर लिखा है क्या कुछ? एज में बी प्रेस्क्राइब्ड. एक मिनट में ये सारे बंद कर लेता हूँ. बहुत सारे ओपन हो जाते हैं ना विंडोज. लॉट ऑफ विंडोज आर ओपनिंग. तो अभी हमारा था ये 109 पर थे ना. तो 109 में क्या हुआ था? अच्छा, एज ही डीम्स नेसेसरी बोला ना, ये था क्या? टू स्क्रूटनाइज द होल प्रोसेस. तो दिस क्वेश्चन इज नॉट वेरी क्लियर. इसमें क्या है? द चेयरमैन ऑफ द मीटिंग में ऑन हिज ओन मोशन.
answer appears to be true, sir.
And meaning that we have order a poll.
I think we can remove that eating spit and talk.
Yes, we have to remove this thing.
Hmm.
Now I think the options are correct. So now what shall be the answer?
True.
B.
B
Yes.
for Bombay, sir.
Naji?
B for Bombay.
B
B,
for
sir.
Bombay.
Bombay.
Next. A demand, but he must have something in mind, maybe some secretarial standard. A demand for a poll, but we cannot go that far. A demand for a poll in the case of a company. I'll ask him. Let me mark
Yes,
it
sir.
right. So I'll ask him okay, what he had in mind while framing this question.
Yes, sir.
Maybe he had some secretarial standard. Section 31. A demand for a poll in the case of a company having a share capital may be made by the members. So this is given in 1091A. So
Yes.
let us again read 1091A. This is 1091A. In the case of a company having a share capital by the members present in person or by proxy where allowed and having not less than 1/10 of the total voting power or holding shares on which an aggregate sum of not less than 5 lakh rupees or such higher amount as may prescribed has been paid up.
Okay.
So it says, in the case of a company having a share capital
Share capital.
by the members present in person or by proxy were allowed and having not less than 1/10 of the total voting power. So everybody cannot demand a poll. So who can demand a poll is answered by section 109. And it is talking of both the scenarios when the company is having share capital and the company is not having share capital. So in case the company is having share capital, then not less than 1/10 of the total voting power or holding shares on which an aggregate sum of not less than 5 lakh rupees
5 lakh rupees.
or such amount has been prescribed has been paid. And in case of any other company, not less than 1/10 of the total voting power.
Hmm.
So now the question.
That's C answer.
B.
Right.
C.
C will be the answer. Right. So 30.
One thing that this
Now
C
next.
and B.
Next question. Next question is a demand for a poll in the case of a company not having a share capital may be made
Yes, sir.
सेम क्वेश्चन वो आ गया क्या नहीं ठीक
और
Same
No, no.
question.
The
नॉट
other
हैविंग
company.
शेयर कैपिटल बोल रहा है ना. देखो पहले में क्या बोला है,
हाँ.
शेयर कैपिटल. अब यहां बोल रहा है नॉट हैविंग शेयर कैपिटल.
Yes, sir.
So by the members
A only. Answer is A.
A.
present in person or by proxy and not
Having
having
not less than
not less than 1/10 of the total voting power.
voting power.
ठीक है ना. तो इसमें ए आंसर होगा, ए और बी नहीं होगा, है ना.
Yes, sir.
तो इसका आंसर हो जाएगा ए 36. So this is given in 1091B. I'll ask him to write the complete with subsection also, है ना. 1091B. Although as you told, he has written the sections but not the subsections. The result of the poll shall be deemed to be the decision of the meeting on the resolution on which the poll was taken.
सिक्स है सर 1096
1097.
2, sir. 7, sir.
7
1097.
Yes. D.
क्या होगा?
D, sir. Delhi.
ठीक है.
Yes, sir.
ठीक है जी, नेक्स्ट देखते हैं. If a resolution is assented to by the requisite majority of the shareholders by means of a postal ballot, it shall be deemed to have been duly passed at a general meeting convened in that behalf. So this section is 110. So let us read 110. क्या बोलता है 110? ये आपका 110 आ गया. ये postal ballot. This is the section. So it says, if a resolution is assented to by the requisite majority of the shareholders by means of postal ballot, it shall be deemed to have been duly passed at a general meeting convened in that behalf. And let us read 110(1)(a) also. It says, a company shall, in respect of such items of business as the central government may by notification declare to be transaction only by means of postal ballot. So central government may prescribe that, okay, these types of business will be transacted only by means of postal ballot, and may, in respect of any item of business other than ordinary business, and any business in respect of which the directors or auditors have a right to be heard at any meeting, transact by means of postal ballot. So, ordinary business and any business in respect of which directors or auditors have a right to be heard. Suppose it is a resolution regarding, say, removal of auditors. So if it is a resolution for removal of auditors, auditors have the right of being heard. Okay, no? So in that case, it cannot be held by means of postal ballot. So they can reframe the questions like this. If a resolution is assented to by the requisite majority of the shareholders by means of postal ballot, it shall be deemed to have been duly passed at a general meeting convened in that way. Now let us see the question. हाँ, तो ट्रू हो जाएगा तो, है ना, कोई दिक्कत नहीं.
Yes, sir.
So this is 1102, section 1102, subsection 2. But आपको क्या करना है, पूरा सेक्शन पढ़ लेना है, because they can ask you other questions, like I told you the question of this removal of auditors. So they will create situations. तो 38 में हो जाएगा आपका B. Now 39. 39 क्या बोलता है? We'll stop at exact 10 o'clock. A company shall, on requisition in writing of such a number of members as required in section 100. Section 11. Let us first read section 111. क्या बोलता है? ये है. A company shall, on requisition in writing of such a number of members as required in section 100. 100 में हमने requisition पढ़ लिया, ठीक है? वो normally वो not less than 1/10 की बात करता है. तो क्या होगा? Give notice to the members. ये circulation है, circulation of members resolution. A resolution can be passed by circulation also. So what is the meaning of circulation? The meaning of circulation is that you are not holding any meeting, but the minutes are going to everyone. Okay? Either electronically or through some other mode, and then they are saying yes or no to that. Give a notice to members of any resolution which may properly be moved and is intended to be moved at a meeting. Okay? And circulate to members any statement with respect to the matters referred to in proposed resolution or business to be dealt with at that meeting. A company shall not be bound under this section to give notice of any resolution or to circulate any statement unless a copy of the requisition signed by the requisitionist or two or more copies which between them contain the signatures of all the requisitions is deposited at the registered office of the company. In case of a requisition requiring notice of a circulation, not less than 6 weeks before the meeting. Just a minute. आ रहा हूं. क्या? नहीं इसलिए किस लिए नाश्ता मुझे नहीं करना है, मुझे मीटिंग में जाना है, नाश्ता हो गया मेरा। Okay, so circulation of members resolution. It says a company shall not be bound under this section to give notice of any resolution or to circulate any statement unless a copy of the requisite. So it is talking of circulation of members resolution. So it now 111 is talking of certain situations where a resolution could be passed by circulation, and then it has to be sent not less than 6 weeks before the meeting. And in case of any other requisition, not less than 2 weeks before the meeting, there is deposited or tendered with the requisition a sum reasonably sufficient to meet the company's expenses and giving effect thereto. Suppose that is to be sent to various members, then provided that if after a copy of requisition requiring notice of a resolution has been deposited at the registered office of the company, an annual general meeting is called on a date within 6 weeks after the copy has been deposited. The copy, although not deposited within the time required by this subsection, shall be deemed to have been properly deposited for the purposes thereof. And the company shall not be bound to circulate any statement as required by clause B of subsection 1 if on the application either of the company or of any other person who claims to be aggrieved, the central government by order declares that the rights conferred by this section are being abused to secure needless publicity for defamatory matter. Okay? And an order may direct that the cost incurred by the company by virtue of this section shall be paid to the company by the requisitions, notwithstanding that they are not parties to the application. And if any default is made in complying, company and RV officer who is in default shall be liable to a penalty of 25,000 rupees. So these are some of the provisions regarding meeting by circulation. Now, आप क्वेश्चन देखते हैं, क्या क्वेश्चन बोलते हैं? क्वेश्चन बोलता है a company shall on requisition in writing of such number of members give notice to members, circulate to members, both A and B. क्या आंसर होगा? This is answer is given in section 111 subsection 1. ठीक है?
Yes.
So it is talking about both the situations. The company shall on requisition in writing give notice to members of any resolution which may properly be moved and is intended to be moved at a general meeting, and circulate to members any statement with respect to the matters referred to in proposed resolution or business to be dealt with at that meeting. ठीक है? So I think we can stop here, है ना? इतना ही करते हैं आज. So because I have to go somewhere. But in the meantime, please read the rest of the sections.